Hey, good morning, everybody. Welcome back. We survived the weekend, and now we've got another week ahead of us. And an exciting week for Mike, and I guess an exciting week for me. I returned to LA midweek for another 4 or 5 days of comedying in Hollywood. Hopefully, trying to learn the craft so I can get on my feet and be a little more entertaining, at least to those who care to listen to my offbeat brand of humor. But Mike, big news for you on Friday. You're hosting an a discussion of Trump's legal difficulties on a large platform, like 800,000 viewers or something. I hope you'll come back and play with us here in our little pond.
Yeah, we'll see what happens. I got an invite over the weekend on Saturday to be party to a segment. It's going to be called Room for Debate, and so I think this is something that will fall beneath the umbrella of the Shade Room for those of you who may be familiar with that side of social media. And I think the Shade Room is going to be more inclined to the Democrat Party for obvious reasons, but the invitation comes from someone that is very close to me, that I've known for going on 10 years now. So it's not something that made its way through the woodwork that would be untrustworthy. So I'll be talking about how Trump's legal matters are affecting his campaign or have affected his campaign, and I'll be learning a little bit more about how disciplined I'll need to be within the confines of what's allowed for the segment.
Well, when is this going to be on, and how do we find it?
It'll be this will happen on Friday. My understanding right now is that recording is on Friday. I'm not sure that it will be live, but it will be distributed thereafter on the Shade Room's social media platform. So they've got about 900,000 followers on X, and I haven't even thought to check Facebook and Instagram. But we'll provide more details this week for sure.
Well, congratulations. Come back to us. We need you. I'll be awfully lonesome here without you when you're a star there in the Shade Room. Hey,
yeah,
so
Fanny, in LA, maybe you can drop by.
Fani Willis, interesting developments on Friday that, as far as I'm concerned, spell her doom. And of course, I always, as always, looking at the world, have to wonder how much I'm seeing what I want to see. So let me fight against the confirmation bias and give you the facts as I understand them. Apparently, some of the lawyers for Trump retained an expert, a digital data expert, to review communications between Fani and Nathan Wade. And Nathan Wade, and also to trace their whereabouts by way of cell tower data. And the forensic report filed in court, I'm told, last Friday, contains the following observations: that prior to the time that Miss Willis and Mr. Wade testified they had a romantic relationship, before that they started to heat the sheets, in other words, they had cell communication 2,000 times over an 11-month period. That's a lot of wrong numbers, folks.
Well, I mean, 2,000 voice calls during the calendar year, or the 11-month period from January to November of 2021. That's 2,000 voice calls. That's 12,000 text messages, Norm.
2,000 voice calls. Do we know the length of these calls?
We don't. I'm sure that is within the data, but no, I do not.
And then also significantly, Fani's phone was within was in close proximity to Wade's home 35 times during that period. Now, Willis did what all lawyers do when faced with that evidence. Well, that doesn't prove there was an affair. The fact that we lied, the fact of the communications doesn't reflect what we talked about. 2,000 voice communications, 12,000 text messages. How long did that interview last when you decided he was going to be an so special prosecutor, Fani? I mean, the bottom line is, I think she lied. I can't imagine communications in that length for any other purpose than fostering intimacy, the sort of intimacy that we're all entitled to, and that everyone hopes for. But in the Willis case, it's something she lied about. And if she got on the stand, took an oath, and lied about a material factor, she should be investigated for perjury and potentially prosecuted for perjury. Independent of that, because perjury prosecutions are very rare, this raises questions about her duty of candor toward the tribunal, a duty that all lawyers share as a matter of professional ethics, and it raises questions about her ability to perform as a minister of justice, which is the primary role of a prosecutor. Some of the dicta, that is spin-off language in Supreme Court decisions, say that a prosecutor's role is to strike hard blows but fair blows because they're ministers of justice. Funny, if you can't tell the truth about who you're banging, should you be banging away on other people in open court? And the answer is no. And so I think that Judge McAfee, assuming that the affidavits contain reliable evidence of the form that we just described, in other words, that there is in fact cell communication between a phone she owned, a phone Mr. Wade owned, assuming that there was in fact reliable data suggesting 2,000 voice communications, assuming further that her phone was in close proximity to his home on 35 occasions, I think they need to be brought back to the stand and ask those questions. And maybe put the expert on the stand. But I think the hearing needs to be reopened because on its face, this is powerful evidence of a relationship that pre-existed her involvement, or his involvement in the Trump investigation, and it's directly contrary to what they testified to in court. Mike, what do you got on the screen there?
Jonathan Turley published a piece on this that I do commend to our viewership as well. I just want to read this component of it. Quote, in her testimony, Willis was combative, declaring, it's a lie, when asked about a romantic relationship preceding her hiring of Wade. Many of the media praised Willis as showing what a, quote, good lawyer she is in attacking the media, the defendants, and critics. If Wade did not stay over, the parties are claiming that his cell phone seemed to. Quote, and this is from the filings from Trump's legal team. Quote, specifically on September 11th, 2021, Mr. Wade's phone left the Doraville area and arrived within the geofence located on the redacted address at 10:45 p.m. The phone remained there until September 12th at 3:28 a.m., at which time the phone traveled directly to towers located in East Cobb, consistent with his routine pinging at his residence in that area. The phone arrived in East Cobb at approximately 4:05 a.m., and records demonstrate he sent a text at 4:20 a.m. to Miss Willis.
I'm home, honey. Thanks for a wonderful evening. I'm still aglow.
Additionally, on November 29th, 2021, Mr. Wade's phone was pinging on the East Cobb Towers near his residence, and following a call from Ms. Willis at 11:32 p.m., while the call continued, his phone left the East Cobb area just after midnight and arrived within the geofence located on the redacted address at 12:43 a.m. on November 30th, 2021. The phone remained there until 4:55 a.m.
I'm lonely, and I'm wondering if you can come and talk to me about your prospective ability as a role in the special counsel. Well, stop and pick something up to eat along the way, but don't stay when the sun comes up. I don't until the sun comes up. I don't want the neighbors to see you here. I mean, look, this is routine sort of data that is used, cell tower pinging, to locate people in criminal cases all the time. Your phone is constantly emitting signals even when you're not talking on it, and the signal is transferred from tower to tower depending on where you're traveling. And in densely populated areas, they can locate your proximity to a given address within a couple hundred yards. So this is going to be hard for Fani to talk her way out of. I think she's DOA, dead on arrival. Let's move on, Mike. As far as your preparation for your big event on Friday, I think that this case is not going to affect Trump's electability. It's not going to be tried before November. Fani is likely to be out. And don't tell me, and don't let anybody tell you that she's being picked on account of her race. She's being picked on account of the fact that she's a liar.
Yeah, I think again the question is about how it affects his campaign. And to me, my theory with this has been that Trump, as the recipient of all sorts of lawfare in the last couple of years.
Target, not the recipient. Yeah.
Well, yeah, and I mean, I use recipient pretty graciously there, but target
you sure did. Yeah.
And what it tells me is that there's something else being communicated within the zeitgeist of American politics right now that other people are interpreting as Trump as sort of the victim, the unwarranted or the unjustified victim of that lawfare, right? And particularly in the case of something like Fani Willis in Atlanta, right? We're talking DeKalb County. We're talking the Young Thug trial as well with racketeering there. There is a part of the Democrat culture in Atlanta that is seeing this for what it is, and that is playing to Trump's benefit. There's, having his mugshot released, right? Then being put on T-shirts, etc. This is not going to bode well for the opposition party to Trump. But I think, particularly in the case of Georgia and the Georgia election interference and this kind of stuff, that these cases are his campaign in one way or the other. And this is an overwhelmingly positive development in his favor, right?
So why don't you reach out to Fani and see if once her legal career is over, whether she'd like to be a co-host on a podcast, just not ours. Hey, big news in South Carolina. Icky Nicky got clocked by Donald. I think 60% of the vote went to Trump and 40% went to Haley in her home state. This two-time governor of South Carolina and former UN ambassador can't even win in her home state. What's up with that?
Well, I think the AP called this before they even had, like, I think they called this just based on exit polling for Trump, which is really interesting, right? So Nikki Haley was the governor of South Carolina 2021. She didn't even crest 40% in the Republican primary there. And the Associated Press called this for Trump even before the votes had actually been tabulated. So that tells you quite a lot. Apparently, Nikki Haley is still saying that they're going to continue on at least until Super Tuesday, which is just about a week away, maybe a little more. But this is interesting to me. So this comes from Town Hall. What I've got on the screen. After getting demolished in South Carolina, Nikki Haley loses a major donor, and it takes a minute to get there. But then it says right there, the list of reasons for Haley to end this increasingly embarrassing 2024 effort is many, but it seems only some of her donors are seeing things. The Koch brothers network, which has backed Ms. Haley to the hilt, recently announced they're cutting their losses, seeing a further injection of their resources being unable to turn things around.
Wow. Well, that's bad news for Nikki. I'd say, I still think she's got no downside in hanging around, because if something should happen to Trump, if he's legally disqualified, if he falls ill, if he gets killed, which, is a possibility in these fractious times that Republicans are going to need someone to stand. But she just doesn't. She may be the last candidate standing, but she's not standing by much. We've got a piece coming out in the newsletter this week on what I think explains the Trump phenomena, and it's becoming increasingly clear to me that in 2024 he is the Republican candidate, because he is the candidate that's basically just saying no. We're not buying. I'm not buying. People who vote for me aren't buying the bullshit. We're not buying the identitarian politics. We're not buying redistributive ethos. We're not buying the notion that the state is necessarily a force for fostering the public good. We're going to question the whole premise that somehow we can have social justice and arrive at equity, diversity, and inclusion in a way that is meaningful. And guess what, folks? If you don't have to be either a racist or an anti-racist. You can just be disinterested in the whole redistributive process. And if you are, you need a candidate, and that candidate is Donald Trump. So stay tuned. Big win for Trump in North Carolina. Excuse me, in South Carolina.
Yes.
Mike said earlier, I sent him a text and it was, about his win in NC. He says, "Is that North Carolina or South Carolina?" I said, "From the north, it's all the same." That's typical New England arrogance and ignorance.
Yeah, you.
Samuel Alito was in the news as having given a dangerous intimation of what is to come for the LGBTQ diversity community. quirky case. The United States Supreme Court decided not to hear a case involving the First Amendment rights of jurors. Jurors have a right to sit on a case, and they have a right not to be discriminated against on account of their religious beliefs. And defendants have a right to a jury of a composed of members of a fair cross section of the community. So in this quirky Missouri case, a DOC employee begins to take up with the spouse of one of her colleagues, and so this poor man's wife left him for another woman. And this sent shockwaves through the DOC, and the plaintiff, in this instance, a lesbian, felt that she'd been subjected to a hostile work environment by the Missouri Department of Corrections. She launched a civil suit, apparently in federal court. I believe it was. I don't know if it was in federal courts, but she launched a civil suit for employment discrimination under Missouri law. It may have been state law, in the course of jury selection, rather, her lawyers asked in voir dire, that is, questioning of jurors, do any of you belong to conservative Christian or religious organizations, or words to that effect? And several said that they did. And on further questioning, the lawyer was able to elicit that some of these jurors who belong to conservative religious groups viewed homosexuality as a sin. And based on that alone, he moved for cause. That is, when you're picking a jury, you lawyers get a chance to strike panelists if those jurors cannot be fair and impartial. And you can have an unlimited number of these cause challenges. States offer varying numbers of what are called peremptory challenges. That is, challenges based not on the fact that a person couldn't be fair and impartial, but for whatever reason the lawyer chooses, so long as those reasons don't rely on race. So her counsel moved to strike these jurors, saying there's no way somebody who looks at a gay person and says you're a sinner could fairly consider a case involving a lesbian plaintiff. And the court granted that motion to strike in two instances. So the case has gone up through the appellate courts, and it went to the Supreme Court. And the question presented was whether on this record, and this record alone, that resulted in discrimination against these individuals on account of their religious beliefs. The court declined to hear the case. Alito notes that he agrees with the decision not to hear it because there were related state procedural issues.
Yeah, they just didn't preserve the objections. The state didn't preserve the objections in the lower court, and therefore it would be a plain error review. The reviewing standard of the Supreme Court in this case would be for plain error only, not necessarily whether there is a substantive issue to take up, a la Obergefell. But here are the issues that we would be talking about, Norm. It says the Missouri Court of Appeals affirmed the dismissals for two reasons. First, it reasoned that the jurors' belief, quote, that Fani's conduct was sinful, meaning immoral and wrong, provided a sustainable ground for, quote, concluding that they could not impartially and fairly decide her claim she was unlawfully harassed due to her homosexuality, even if those, can you pronounce that for me, please, Norm? I've never seen that word before.
Even if those Venire members
claim that their religious beliefs would not prevent them from serving. Second, the court concluded that jurors had been dismissed not on the basis of their religious status, but on the basis of their religious beliefs, which I think, Norm, if we take this as a whole, is that not a weird departure from the First Amendment standard, that not on the basis of their religious status, but on the basis of their religious beliefs? In other words, they can be Christians provided that they don't behave like Christians?
Well, no, I mean, I think that the reason I'm glad cert wasn't granted in this case is the lawyers did a horrible job of the voir dire, and the trial court did a horrible job in analyzing whether the jurors should be struck for cause. The intermediate question that was never asked is, well, notwithstanding, and this is what should have been asked, and which is what would have made it a better record had these questions been asked. Look, I understand your view ma'am, that you view homosexuality as a sin. Have you ever heard the expression "you can hate the sin but love the sinner"? Yes, and are you saying, ma'am, that as a result of your view that homosexuality is a sin, you couldn't be fair and impartial about a claim raised by a homosexual? And if the woman said that, then she should be excused for cause. But she didn't say that. She wasn't given an opportunity to go that far. They simply said and imputed to her a bias because of her beliefs. One of the Vanilla Purple person said, "Yeah, homosexuality is a sin, but so is gossiping." And does that mean she would be excluded from any case involving a gossip? And so I think that this was a horrible record. But I think the thing that attracted the media attention to Alito's position was earlier in the decision, where he said, "This is the sort of thing that I worried about when we decided Obergefell versus Hodges. Hodge rather, people who have traditional religious beliefs are now going to be regarded as bigots because of those beliefs. And the whole substantive due process justification for gay marriage is that there are fundamental rights that people have to or determine their own sense of meaning in the universe, to paraphrase Kennedy's language from Casey versus Planned Parenthood. And we can't interfere with those. But what we have are people with traditional beliefs, and those traditions stood for centuries, stood for the first couple centuries of the Republic. And now the Supreme Court has abruptly turned course and said, well, you can have your beliefs, but we live in a brave new secular world. And how are we going to accommodate all that? I'm not sure that the critique of Alito is justified here. I don't know that he was wise in tipping his head in the direction of Obergefell versus Hodges. I do think the issue here is the adequacy of the voir dire. And Mike, I think the court could have reached this on plain error grounds. I just think they didn't like the record they had before it, in part because the voir dire was so sloppy. And there are substantial questions about what really happened there. And it's an example of the fact that if you're in court and you're litigating an issue, you need to press the issue. You need to make clear exactly what went on, because it's
Well,
not clear in
yeah.
this case.
Well, point for the unimpressive state's attorneys then, huh? I mean,
I guess.
I don't mean to laugh just at that, but I do think it's interesting that I like Dawn's question, right? And because when I was reading this, all I was thinking of was, well, what is the truth of the underlying matter, right? So we do have a government employee that filed an employment discrimination claim. You, Norm, address some of the background facts, and it's quite possible in this case that the government is not in the wrong, that there is no hostile work environment, et cetera, et cetera. But from personal experience, I know that this is the issue necessarily, is that someone is complaining because the EEOC will be involved, and there will be some payment of money irrespective of the substantive merits of the underlying allegation. That's in general the way that these things work, especially when
Yeah.
when the defending party is a state or a federal agency. Um, Dawn's question: would Muslims be denied on the same basis, or just Christians? I think the way I would approach that question, Dawn, is to just ask whether the defense attorneys would have the audacity to challenge a Muslim member of the jury, and then I guess solo them out the same way, single them out the same way that the member of the defense team did here with Christian churchgoers, right? One of them was a pastor's wife, by the way, Norm.
Yeah, no, I get it. It's an odd decision. It's a troubling decision. I think they were right not to take cert, but I think I think Alito is signaling an interest in voir dire. I just, as I haven't read the trial transcript, so I need to be clear and honest with you all about that. But as far as Alito's brief report is concerned, the voir dire was just not well done. It's hard to know exactly what happened there. Hey, I
Hans
know we didn't. Yeah.
Here's a question for you. Hans asked, and there are two questions here, one from Lawyer Will, one from Hans. Hans asked, could I be removed if I had no religion?
Well, I mean, again, could you be removed? I mean, anything can happen in a courtroom. I don't understand the question. So am I looking for people with religious convictions? And could I say that a person without religious convictions is a person without morals? So the question would have to be, I get, I'd have to, I'm hard, Hans, I'm hard pressed to imagine what the question would be in voir dire. So let's just play it out. Sir, what religious organizations do you belong to? Objection. That's not necessarily intruding into the juror's privacy. Many courts would sustain that objection. Suppose the court didn't. I don't belong into any church whatsoever. Really? How's that? Well, I don't believe in God. Judge, I'm out of the juror's presence. I move for cause. The man is godless, and a man who's godless has no soul, and a person who has no soul has no conscience. And without a conscience, how could I arrive at any conclusion that this juror could do the right thing or could do justice? I'm going to deny that motion. There's the court would say. So I think that's just hard to play out, Hans. That's just hard to play out. I don't think those questions would be permitted. I think in this case. Again, reading Alito's decision, I'm not sure what happened in that voir dire. It just doesn't resemble anything I've seen in a courtroom.
Lawyer Will asks, Norm, what is your opinion on substantive due process and constitutional analysis?
Man, if I had more brains, I could write a book on that topic. What is substantive due process? So the 14th Amendment says that the state can't deprive a person of life or liberty without due process of law. And then there's this procedural and a substantive aspect to it. Procedural means you have notice and an opportunity to be heard before you suffer a deprivation of a property or liberty interest, however those are defined. Substantive due process says there are some rights that we have that are so fundamental they can't be infringed upon. And those rights are consistent with our concept of ordered liberty. And there are very few things that the courts consider to be such a right. In the so-called Lochner era, in the early 20th century, courts began to strike down state regulations of economic activities as interfering with our substantive due process rights to freedom of contract and so forth. That these were regarded as fundamental rights that government couldn't touch. And now liberal jurists critique the Lochner era as being somewhat backward and retrograde. The modern conception of substantive due process follows Anthony Kennedy's reasoning in Casey versus Planned Parenthood. And I can't recall the exact language, but it says, each of us has the right to define our own conception of meaning in the universe. And this is reflected in our intimate choices. And the intimate choices involve such things as who to marry. So the state can't impose restrictions on marriage, the so-called Loving decision, which overturned state restrictions on interracial marriage, nor can the state compel you to do certain things, and but more likely, the state cannot prevent you from doing those expressive acts that give you a sense of meaning in the universe. And what could be more intimate than the sense of who to marry and with whom to spend your life? And thus, the state cannot interfere with your decision to marry a person of the same sex. And that's the current status of the law. Now, it hasn't gone so far as to say, well, in a polyamorous society, neither can the state say I can have just one wife. If all three of us consent and it's consistent with our conception of meaning in the universe, why not three? And, the problem is there's no principled reason to draw the line there. History weighs against these conceptions over time. We haven't had a history of gay marriage in the United States, and the teaching of the Christian churches has been typically that marriage is a sacrament, one woman, one man, and the purpose of life, the purpose of marriage is to raise a family and to produce a stable society. Many people believe that still, including probably these two struck jurors in the Missouri case. The problem, as I see it, is twofold, Will, with substantive due process. First, it's limitless. And so the polyamory case, I think, illustrates it. If you're going to draw a line, you're always going to arbitrarily be drawing lines in what the state can prohibit. So I think as a source of fundamental rights, it's troubling to me. When it flies in the face of tradition, it can be very destabilizing. I think in general, though, the notion that government is one of limited powers, I support the notion that there are certain things that should be off limit to governments. The problem I think we have is when we've lost any sense of underlying consensus of values, when everything is up for grabs, as it is now, substantive due process becomes a sinkhole, and the courts are forced into the decision of drawing distinctions that don't mean anything to many people, that are offensive to others, and that become valorizing for only a small segment of the population who decides that their lives are so precious, the rest of us have to honor everything about them, even if it's offensive to us. So I think substantive due process, will, is a minefield, and I tap dance through it at my peril. Early as a lawyer in law school, I loved the Griswold versus Connecticut decision. That was a decision, I think, in 1960 something or other, 64 maybe, that held that couples had the ability to choose, that persons had the right to, married couples at least at that point, had the right to choose to use contraceptives. The state couldn't prohibit that. And where did that right come from? It came from a sort of implicit right to privacy. But if you look at the Griswold decision, it's an absolute mess, because that right to privacy doesn't sound in any particular amendment. What the court had to do was read the amendment: the First Amendment right to freedom of expression, freedom of religion, freedom of speech; the Second Amendment right to bear arms; the Third Amendment right to prevent quartering of soldiers in your home; the Fourth Amendment right to be free from unreasonable searches and seizure; the due process rights in the Fifth, fair trial rights in the Sixth, blah, 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 blah. And I said, look, if you look at all of these rights and you tease out their implicit meaning, there is a penumbra, and emanating from that penumbra, emanating from that penumbra is a right to privacy. And I think constitutional scholars rightly ridicule that. I mean, I had to look up penumbra in law school. I never heard of the word, and I kind of knew what emanating was, but I was thinking, holy cow, I'm getting a license where I can go out and press claims that emanate from this penumbra. That means just about everything. Yeah.
Check out
I'm
my
like a kid in
Voir.
the candy shop. And that's the bottom falling out of pluralism. And I think that when we had a commitment to a Judeo-Christian culture, and when we had a threshold assessment or belief that were some values that were fundamental and didn't need to be discussed because we all shared them, substantive due process was probably a safe gamble. But in a world where the bottom has fallen out of pluralism, it's an invitation to anarchy and chaos. And I think it's troubling. And that's my best. It's a long answer, Will. It's the best one I can give. I'm deeply ambivalent about substantive due process.
Yeah, and lawyer Will followed up by saying that that Griswold was the foundation for Roe v. Wade, which I think we would agree
It
with.
was.
Moreover, I think that this just calls back to last week when I was discussing, the absence of good faith or moral authority of the current iteration of the United States and its institutions, right? Is sort of the issue that you're teasing out by talking about substantive due process, is that maybe there is a world in which substantive due process, as applied and as pressed through the courts, could end with sound, reasonable conclusions, but that does presuppose good faith in the application of that as a legal doctrine. And I think, sadly, as you've already dictated here, Norm, we live in a world which, parties are now asserting these applications of substantive due process and asking courts to make delineations between lived realities that have zero application to, the overwhelming majority of the population.
I think that's probably true, but although I wouldn't say, I think that the outliers who raise these claims are operating in good faith. They're operating from an expressive point of view, and that is the expression of themselves is a primary value. And so we live in a culture that values expression of idiosyncrasy to the exclusion of everything else. And it seems to me that we've lost a consensus of fundamental values. We've lost the ability to distinguish between better and worse, and we're worse off for it. And the law can't solve that problem for us. We have to solve it in ways independent of the law. And I think the problem of our times is that we lack a moral consensus, but we have a body of law that was rooted and fostered in a shared consensus. And in the absence of that, the law is untethered and becomes an ass.
It makes me think that the legal profession has failed our society in many ways, but it principally in that way, right? It's often lawyers that are willing to press the cases that are too divorced from the practical reality of what they're pressing through the courts and the long term consequences. You know, that would require, you know, I think some level of narcissism that we don't want attorneys to really indulge to weighing that kind of thing. But it does concern me that there seems that lawyers exist in this sort of this in between, right? The gray area between, you know, lived reality and the court system. We are that vessel through which cases navigate their way in the judicial system. But in mass, we've largely seen the legal profession turn its back on fundamental rights in the last decade, right? And even institutions like the ACLU and the Southern Poverty Law Center, et cetera. You can, from any vantage point, Norm, whether it's COVID, whether it's the southern border, these sorts of issues, we've seen what was once a more noble pursuit, right, in the movement for equality, or at least as advertised, to something entirely different. And I often sit back thinking that perhaps lawyers, there needs to be a way to check for that, not just to pass an exam and achieve a bar license, but there's something lacking in the oath that we are taking toward the court and to the Constitution.
Maybe I just you may be right, Mike. It's a big question. I mean, books can and should be and are being written about this, I presume. It seems to me that a law school education is brief. It's only 3 years, and the first year is spent largely learning the vocabulary and the mechanics. The second year you round out some fundamentals, and the third year you get some electives, and then bingo, you pass a bar exam, which represents to the world that you're minimally competent to identify a problem when it walks in the door. But not one of these classes is designed or intended to address fundamental moral issues or even fundamental social issues about what makes a good society. Now, the critical legal studies movement and movement lawyers are free to import their sense of what makes a better society into the empty vessel of the law. Those defending traditional things don't usually have the same infrastructure to work with. What they're drawing from is old social capital. And as that gets spent down, I'm just not sure where the law goes. I mean, I think, we should talk tomorrow about the IVF decision out of Alabama. I mean, it's a huge decision. As a certain presidential candidate would say, it's a huge decision. If we are merely the sum and substance of our genetic material, then it's all present at the moment Madam Egg invites Dr. Sperm in for a visit. And at that moment, there is life. And at what moment do we get to say it's not life? At what moment does that life become a person? Is it a person from the moment of conception? And if it is, what consequences from that follow? The Alabama Supreme Court has decided to double down and say that life begins at the moment of conception, and therefore personhood does. If you destroy a fertilized egg that's being kept in vitro, let's say, at a storage facility, you're taking a life. Does that become homicide? And what do we do? That's a point where technology has forced us to confront moral issues we didn't have to confront before. But the very definition of personhood and what constitutes a person is steeped in so many extra legal factors that these cases, I think, approach lawyers flat-footed. We don't have the training, education, or expertise as a result of our legal educations to deal with these. All we have is our values, our religious traditions, and our philosophic commitments, which I think we bring to law school. But anyhow, I got to run. I've got some oncological problems today. What am I talking about? I view the state largely as a tumor in the lives of my criminal defense clients, and I've got several of them waiting for me in a court about an hour and a half's drive from here. So I better hit the road.
Yeah, get in the car, get on the road. Thank you, those of you on Rumble, Jackson, Lawyer Will, Freedom Lover, for your contributions. Lawyer Will still thinks that you need to to write a book on substantive due process for lay people.
He may be right. If I get suspended from the practice of law, the appellate court, by the way, is still sitting on that decision. I'll put that on my list of things to write. But I mean, there is a book. There are books in that, Lawyer Will. It's a huge topic, and I'm sorry that I rambled on about it.
Yeah, he says specifically for lay people, right? So
Yeah, got it. I got it. All right.
Norm, see you tomorrow. Newsletter will be out today. Find us on X, YouTube, and Rumble. See you tomorrow. Bye, everybody.
AMF yo-yo.
AMF yo-yo.